Hi guys, this is Steve from Expert in Legal Matters. Trusts, wills and estates. This is a book I use a lot. I read it quite a bit. I've got many books actually, but this is one of the best, and this is done by Alexander A. Hoover Jr. He's American. The great thing about it is he's actually worked all over the world, and he's got one of the best legal guide to wills and estates. He is priceless on this stuff. Right, so I'm going to go through a few things with you. Trusts and the creation of a living trust. So I'm going to read a few things so you get this, so you understand it. Yeah. Trusts and creation of a living trust, which is discussed in more detail in chapters 11 and 12. Yeah, well, we know this. Naming yourself and or your spouse as a trustee, and placing your assets into the trust during your lifetime has become a very popular method of avoiding probate. Absolutely correct, spot on. Some attorneys, however, draft such trusts to provide that on the death of the grantor, the person who created the trust, the assets remaining in the trust will be distributed to the grantor's estate. This is sort of like building a lifeboat and then poking a large hole in it. I strongly advise against such trust arrangements. They carry the same hassles and headaches as a life insurance policy designating the estate as beneficiaries. Well, I know that, but it's nice just to let you hear about it every now and again. Lawsuits and inheritances. There may also be assets that must be probated and passed under the terms of your will, whether you like it or not. These are usually assets that become yours after your death. Or on account of your death, such as damages recovered as a result of lawsuits brought for personal injuries that lead to your death, or inheritances from a person, love that fictitious name, who died shortly before you, leaving you a share of her estate. Yeah, absolutely correct. The first situation could arise, for example, when a person was injured in an auto accident and a period of suffering death. The executor person's estate would sue the negligent party for personal injuries on behalf of the deceased, as well as for causing the deceased's death. The portion of the recovery received by the executor that is attributed to the personal injuries will become part of the deceased probate estate and will pass under the terms of the deceased will. The other portion usually passes according to special state law. Well, this is American, this one, so I'm just giving you a guideline on this one. Relating to disallowance of wrongful death procedures, in most cases going through the deceased spouse and children. Yeah. So that's basically telling you about that. So we look forward a little bit to some interesting ones. That's nice. Right, understanding the difference between real and personal property. Real and personal property, guys. What is property? The term property is often interpreted by the lay public to mean real estate. In fact, property is the basic legal sense means anything that is capable of ownership. In this regard, it could include everything from a theatre ticket to a yacht, from a share of a stock to a movie contract with MGM, obviously, from an apartment lease to ownership of the Empire State Building. All involved a property right of some sort. All property rights are divided into two basic categories, real and personal. Real property. It is a property interest in real estate, that is land. A property interest in real estate could include a lease or a mortgage. Could include a lease or a mortgage, as well as deed to the real estate itself. When buildings are constructed on land, they generally become part of the underlying real estate. Well, that's right, because it's your estate, so that's true. That's very true. Personal property isn't a property interest in anything other than real estate. Personal property. Did you get that, guys? Personal property is any property interested in anything other than real estate, and could include shares of stocks, promissory notes, a piano and automobile, or a copyright. Personal property is divided into two categories: tangible personal property and intangible personal property. Basically, tangible property includes things you can move and touch and have some inherent value, such as furniture, jewellery, clothing, paintings, collectible coins, rugs, etc., etc., etc. Intangible personal property includes things that in themselves have no value, but which represent the right to something else. For instance, a share of a stock, which represents the right to dividends, and a share of assets. If the company is liquidated, copyright, which represents the right of ownership in a book, a song, or a work of art. Royalty interest, birth certificate, which represents the right share to a profit in some resource, or a promissory note. Now, promissory note keeps coming up every now and again, which represents the right to collect money from someone. Most wills separate only tangible personal property from the rest of the estate, and therefore the rest of the estate normally includes tangible personal property plus all real estate. Quite often there are more problems associated with tangible items of normal value, i.e. mother's engagement ring, than there is with other properties such as substantial value, as illustrated below. Great. Yeah. The bit I like the most. Who should be your trustee? I like this one. If you fund your revocable trust, place your assets in it while you are alive and you are foolish not to, then you should usually be your own trustee. Many people, even some attorneys, raise eyebrows at this, since for some reason it's a little unconventional. I've had many clients and readers tell me they have consulted an attorney on the matter, and he or she has said it could not be done. Regardless of what they are told, even by such poorly informed lawyers, it can be done and is highly advisable, assuming you want to keep direct control and access to your funds and other assets. Note that it is rarely the case with a revocable trust. A revocable trust, guys. Can't do a revocable trust. Under trust law, it's quite permissible for you to be the donor. You hear that? Under trust law, it's quite permissible for you to be the donor, trustee, and beneficiary of your trust all at the same time, so long as your trust provides for some other beneficiary or beneficiaries after your death. Absolutely correct. This is called a gift over. Gift. I love gifts. Naming yourself as an initial trustee allows you to maintain full control over your property, as long as you wish and are able. In the event of your death or disability, your trust would be provided for a successor trustee who would take over the possession for you and administer the trust properly for your own and your family's benefit. Absolutely correct. Spot on. The successor trustee who takes over it of you are ill or deceased is guided and restricted by the terms of the trust. He cannot use the funds for his own benefit unless the trust allows it, or go against your instructions. If he does, he will be personally responsible for his breach of fiduciary duties. The duty of a trustee always to act in the best interests of the beneficiaries and in accordance with the terms of the trust. Although naming yourself as a trustee is an easy choice, selecting a successor trustee is often not so easy. For large estates, a successor trustee in many trusts depends on provisions, most often to be independent for one or more tax purposes. This would be the case, for instance, when you wanted the trustee to have maximum discretion to distribute trust income or principal to your spouse and children after your death. In this case, having a spouse or a child as trustee could cause a loss of tax benefits, although your spouse or child could serve as a co-trustee with the independent trustee, so long as the trust provides that she or he may not make unrestricted distributions to herself. On the other hand, if you don't mind providing for a modest restriction on the trustee's discretion, you can name your spouse and or children as successor trustees of trust under which she is a beneficiary. Yes, you read that correctly. All that is necessary is to include what is called an accessible standard to guide the trustee into exercising discretion. The actual language would be something like, the trustee may pay to my spouse such amounts of income and principal of the trust as the trustee in her sole discretion determines it appropriate for my spouse's health, education, maintenance, and support. Unfortunately, many attorneys like to get fancy and creative with this accessibility standard and use words like IRS or HMRC. Well, that happens. That's just life. Yeah. Love this book. Anyway, just a small one on rules, estates and trusts, guys. Something I like reading a lot of. So there it is. That's a legal one. That's so. But it tells you on it quite clearly there that you can be the executor or trustor or donor, trustee and beneficiary all in one. Is it in black and white? So anyway, just give you a short one there, guys. This is Steve from Expert in All Legal Matters, and I hope that helps you off a little bit with just that. Have a good evening. Catch you later. Yeah. Bye.